Ladies and gentlemen, welcome to this new episode of the BUL Emerging Law Voices series. Here on the BUL campus, we have the pleasure today to be hosting a specialist in environmental law and beyond that. Ladies and gentlemen, today with us here, Dr Agnes Rydberg from the University of Sheffield. Agnes, and we can speak in the singular because we happen to know each other. Welcome here on campus, and it's a pleasure to have you with us.
Thank you so much for having me. It's a great pleasure to be visiting this fascinating series, so thank you so much.
Agnes, you have recently, I spoke before about your expertise in international environmental law, and of course we're going to touch upon this issue, but you have recently also published a book. You have published a book with Brunel, and do you want to tell us a bit about this book?
Yes, absolutely. It's a book that really builds on my PhD research in the law treaties, and it looks at the obligations of states that they have in relation to pending treaties. So when they've signed a treaty or ratified a treaty, but before that treaty enters into force. And it really examines one provision of the Vienna Convention on the law of treaties. It's Article 18 of the Convention, which creates an obligation not to defeat the object and purpose of a pending treaty. Now, this is a bit of a puzzling obligation. It hasn't received a lot of attention in scholarship. It's very rarely induced by states in dispute settlement procedures. So the book really tries to offer a complete examination of what this obligation entails, how it can be utilized in international law, and offer some kind of insights or nuances as to how it might apply to temporary events in international law.
I guess how easy is it for states not to defeat the purpose of the object of a treaty in the negotiations phase when everything is dynamic and political up to a sense?
Yeah, and I think that's the main reason for why this duty doesn't start until they have at least signed the treaty, because only then do you know what the treaty will actually look like. You will know what obligations the treaty establishes for the future. And of course, when we're only in the stage of negotiations, we don't know yet what obligations states will have to comply with. So it's difficult to defeat the object and purpose of an undetermined treaty. Yeah.
A very subjective also kind of question, but
yes.
A very intriguing one. How often do you think that states defeat the purpose and object of a treaty in their lives as states, in their practice?
Yes, I mean, I think we've seen probably few examples in practice up until this date. I think by using the word defeat, the drafters of the Vienna Convention really wanted to create intentionally a very high threshold. They used a different word when compared to when we look at reservations that would be incompatible, for instance, with the object and purpose of a treaty. So I really think that defeat sets a very high threshold. I discuss, for instance, whether a nuclear test would defeat the object and purpose of the pending treaty, the nuclear test ban treaty. And I think it's interesting that many states that previously conducted nuclear tests stopped doing so once they've signed the treaty. The treaty is not yet in force, but I think that's something that shows that perhaps a nuclear test, once you've signed or ratified a treaty prohibiting nuclear testing, would potentially defeat the object and purpose of that treaty.
It shows that international law has teeth, because unfortunately many members, especially of the wider public, they think that international law is not necessarily something that is tangible and is a legal field. So it shows that although sometimes, of course, there are violations, still international law has a substance and an essence in the international relations arena.
Indeed. And I think, yes, it's like you said, sort of defeating whether someone has defeated the object and purpose of a treaty is a very subjective assessment. We've had cases where you have the use of armed force against another state that is clearly defeating the object and purpose of a treaty of friendship, for instance, but that's also in the nature of a treaty of friendship that is sort of intended to promote, of course, friendly relations. So yeah.
I think we're talking now about the law of treaties and about treaties are contracts in essence. As we know, maybe it's the projection of contract law in the international arena. And of course, I started saying that you have an expertise in international environmental law. Climate change is in the core of the public debate nowadays. how much feasible do you think, or how much wishable is it for climate change and the problems and the challenges that it brings forth to be tackled through a treaty or a soft law document like the Paris Agreement that we have?
Yeah, I think this is a very, very difficult question. I think there is no straightforward answer. I think if you look from the point of view of science, the answer is much more straightforward. Science is clear. I think there's a consensus on science now that, yes, we need instruments, legal instruments, to combat the effects of climate change. So I think the world is really ready for a hard binding treaty in that sense. I think at the latest COP meeting in Dubai to the United Nations Framework Convention on Climate Change, the parties really emphasized in the decision that although they've done progress, they are not yet collectively on track in achieving the goals of the Paris Agreement. So I think science is clear. We need instruments, legal instruments, to combat the effects of climate change. That said, I also think that the recent COP showed also how difficult it is for states to come to an agreement on legally binding standards. They agreed to transition away from fossil fuel, for instance, but they couldn't agree on abandoning fossil fuel in its entirety. So what usually happens in the framework of binding treaties is that we have a smaller group of states whose decision is being blocked by, or the smaller group are blocking the decision proposed by a bigger group of states. They come to agreement on some kind of text, but we're lacking ambition. And at the same time, the effects of climate change are becoming increasingly...
You say something interesting. We are lacking ambition and a target purpose. How much do you think that corporations, multinational corporations, play a role, and how easy it is to bring these corporations also on board and participate in the global game of trying to figure out how we can tackle the climate change problem?
Of course, because corporations weren't traditional actors in the international legal order, the question is how do we impose sort of international standards on those? I think from a personal point of view, they play an important role, of course. They are contributors to greenhouse gases emissions, and there is a responsibility that comes with that. I think we've seen some really interesting developments in the Shell case in the Netherlands, where basically the court ordered Shell to reduce their greenhouse gases emissions and set more ambitious targets for the future. Now, of course, that judgment has been appealed, and it remains to be seen what happens in the future. But I think that shows that we are seeing very interesting trends and developments in this regard that extends what had traditionally been obligations of states to now also obligations of corporations.
This will be my next question. How much do you think jurisprudence and the cases that are about being open also before the European Court of Human Rights and also in domestic courts are going to propel a change when it comes to the climate change challenges?
Yeah, I think on a domestic level, individuals and organizations have been successful in bringing change. We've seen cases in the Netherlands, in Germany, where Germany actually made amendments to their environmental law legislation, etc. And yeah, it remains to be seen whether the European Court of Human Rights will follow suit, basically. There are 3 pending cases now on climate change obligations.
In your opinion, what's the difficult aspect that the European Court of Human Rights has to tackle in these cases?
Yeah, I mean...
Expertise, the lack of experts, maybe procedural issues that have to be addressed?
Yes, I think procedural issues is definitely one thing. What kind of scientific evidence do we need to look at? How do we determine the extent of obligations on member states? Of course, climate change is something that has been created by all states in the international community. How do we allocate individual responsibility to states? I think another really interesting point that is asked to the court is the question of discrimination. One case is brought by a group of younger people, and they're also arguing that Portugal in this case is breaching the prohibition on discrimination because climate change disproportionately affects younger generations because they will suffer the consequences more. And this is also something that will be, really interesting to follow because we haven't really seen that kind of claim in other climate change litigations proceedings before. So, yeah.
And Agnes, in essence, we're speaking now how law can impact on the climate change. The question is, do you think that climate change as a phenomenon eventually will impact on the genesis of law or the evolution of law? Are we going to see new conventions, new legal norms emerging out of the climate change phenomenon? Yeah,
I mean, I think we to some extent have already witnessed this. In summer 2022, we had this remarkable decision adopted by the General Assembly that recognized a right to a healthy environment. And before that, there was a debate as to whether that right really existed, how it existed. So yes, I think climate change has the potential on impacting law. I think it's done so already to a certain extent. And really this is something that is being pushed by younger generations in many cases. It was a group of youth from Vanuatu that actually pushed for the call to the General Assembly to ask for an advice or opinion from the ICJ. This is again something that might have an impact, depending on what the court says, on the law, or clarifying the law, what the law is, that can provide guidance for national courts. So I think we have a very exciting year or two ahead of us.
It's very interesting indeed what you're saying, because we see here in the climate change discussion a blend between the new generation and the old structures, meaning the ICJ, the classical structure of international law, being kind of used in a good sense, meaning having the new generation, the younger generation, resorting to these older structures in order to be able to bring a better vision maybe for themselves and for the young people around the globe. So it's very interesting if now the old structures are going to be able to cope with the demands and the voices of the newer generations, because sometimes newer generations bring forth another impetus in the whole procedure.
Yes, and I think it's really remarkable what many of those groups of youths have achieved so far. And it shows, I mean, we're talking about ambition, it really shows great ambition, and they are using law to make a change, and they are basing their claims on the adverse effect and impact of climate change. So, yeah.
And how much do you think that the climate change discussion has changed also the focus of environmental law, meaning in the past we knew about pollution cases. These were the classical transnational, transboundary cases about when it came to environmental law. Nowadays, through climate change, the emphasis has gone from the air to the sea. Do you think that in essence it's a shift of the emphasis when it comes to international environmental law? And how does the impact on the law of the sea actually create a new momentum also for the field of the law of the sea?
Yeah, again, another really interesting question, because when we look at the law of the sea, and of course the main instrument relating to the law of the sea, the UN Convention on the Law of the Sea, the drafters didn't at all discuss or envisage what impact climate change could have on the sea or the oceans. It wasn't discussed by the drafters at all. They didn't foresee the possibility of moving land boundaries due to rising sea levels, etc. Now, it's also land-based pollution that accounts for almost 80% of marine pollution. That is the cause of the rising sea levels. That said, sort of climate change instruments, so the UN Framework Convention on Climate Change and the Paris Agreement, they pay very little attention to the oceans. So the oceans and the effect of climate change on the oceans is something that's really fallen between two stools. So I think more coordination is needed in this regard. We see references in ITLOS to relevant international legal standards and rules, etc. But I also think those are fairly weak references. It is not clear how those internationally accepted rules and standards can assist the ITLOS in developing the ITLOS regime. So I think we need more coordination in this regard to sort of address this gap of climate change and the sea. And of course, I mean, looking forward, this is something that might be addressed by the International Tribunal of the Law of the Sea in their ongoing advisory proceedings.
This will be my next question, because in essence we have the advisory opinion pending before the International Court of Justice on climate change.
Yeah.
But at the same time, as you said now, we have also ITLOS, which is the International Opinion for the Law of the Sea, and the question will be whether ITLOS could also play a role, or by definition is going to be subsided, be put on the side by the more cardinal role played by the ICJ.
I hope not. I don't think necessarily there is a sort of competition in that sense. The questions are also quite different. The question asked to the ICJ focuses more on climate change instruments, human rights treaties, the Paris Agreement, but it also refers to the question of the rights of present and future generations. And of course, the jurisdiction of ITLOS is confined to the UNCLOS as such. So I think they are having, although the questions broadly revolve around climate change obligations, I think the focus is quite different between them. That said, to the International Tribunal for the Law of the Sea, I think several states in their submissions really emphasized, however, the link or potential link between the UNCLOS and the Paris Agreement and the Climate Change Convention. So yeah, if they entertain the question, if they decide to give an answer to their respective questions, I think they have potential of addressing quite different aspects of climate change.
Which is very important to see the synergy in international law between different fields and different courts.
Yes.
Because, as also viewers and listeners know, there is fragmentation in international law, but this doesn't mean there is chaos in international law. There is harmonization between the different courts, and this creates a very kind of harmonious system in the international justice. Agnes, we spoke about, so far we're speaking about international environmental law and the junction between the law of the sea. You're also an assistant editor in a series about environmental law. That means you have the opportunity to receive papers and to review papers of potential contributors. Since this series is also for young people who want to aspire to become barristers or to have a career in law, and now we're speaking about environmental law, what piece of advice would you give to potential writers to focus, meaning in the law of the sea and climate change junction, or to see environmental law in broader terms and not necessarily stick themselves only to the law of the sea component? Yeah,
I mean, I think international environmental law is such a vast and broad field of public international law. There's a lot of intersection of more specialist area of environmental law in the sense of biodiversity, climate change, marine pollution, etc. And how that also intersect with more general public international law issues. I think in terms of advice, of course, we always as scholars want to bring something new, something original, and I think in the field of environmental law, there is a lot of developments to work with. Environmental law really, international environmental law really sparked only in the 1970s, where we had the Stockholm Declaration, the Stockholm Conference, and there has been so much happening. So I think work that really demonstrates and showcases how international environmental law is gaining in value and significance is really important, both from the aspect of public entities, governments, obligations under climate change regimes, but also, like we discussed earlier, public sector, businesses and human rights, etc., trade-related issues. Environmental law really links into so many different areas.
I guess we both work in the field of international law, we serve international law, but there's a big competitor in international law, as we know, which is called European law, EU law, and our viewers have to know that something distinct from international law. My question is, how much do you see the European Court of Justice, the EU judicial organ, playing a role in environmental law, and maybe what's the relationship of EU environmental law with international environmental law?
Yes, I think on an EU level, of course, we're looking at more uniform standards as applied within a larger group of states. I think they have a lot of sort of leave room for negotiations in the sense that they can exercise a lot of pressure as a joint entity coming together, 27 member states. In terms of the Court of Justice of the European Union, again, we see interesting developments going on. There is a pending case between the Czech Republic against Poland. So it's one of the first instances of interstate dispute settlement in relation to the use of fossil fuel in this case and use of a coal mine. So on a European level, we might see the first interstate litigation cases, and it'd be interesting to see what standards the European Union will potentially set for potential interstate litigation outside the EU as well.
Indeed, and also globally, as you say, it's not only the EU, but the ability of the EU to actually cast its influence also in other continents, in other jurisdictions. Agnes, in the University of Sheffield, you have the pleasure to be Deputy Director there in the Sheffield International Law Centre. Do you want to tell us a bit about the centre in a nutshell, about your role there, and maybe the activities that the centre undertakes?
Absolutely. So I'm the Deputy Director for the Sheffield Centre for International and European Law. And in this role, primarily we work with collaboration between colleagues, but also externally with other academics, with other institutions, both in the UK, but also beyond the UK. So what we really do is to organise events open to the whole university, to students, but also to the public, for anyone who's interested in attending. And I'm proud to say that we've had lots of members from the public attending those more academic events. So it's a great way of establishing contacts within academia, but also
very
outside.
Important to open academia to the wider public, but we do also here in the BUL, to do something also that benefits the wider public and not only their fellow academic members.
Yes.
Agnes, thank you very much for this discussion. Ladies and gentlemen, it was Dr. Agnes Rydberg from Sheffield University together with us today. We bid you farewell and we look forward to seeing you in the next BUL Emerging Law Voices episode.